killing more than 1,200 persons, injuring thousands, and abducting some 240 people, many of whom continue to be held hostage. Following this attack, Israel launched a large-scale military operation in Gaza by land, air, and sea, which is causing massive civilian casualties, extensive destruction of civilian infrastructure, and the displacement of the overwhelming majority of the population in Gaza. The Court is acutely aware of the extent of the human tragedy that is unfolding in the region and is deeply concerned about the continuing loss of life and human suffering. The ongoing conflict in Gaza has been addressed in the framework of several organs and specialized agencies of the United Nations. In particular, reservations have been adopted by the General Assembly and the Security Council of the United Nations, referring to many aspects of the conflict. The scope of the present case submitted to the Court, however, is limited, as South Africa has instituted these proceedings under the Genocide Convention. The Court then turns to the conditions needed to be fulfilled in order for it to indicate provisional measures. With respect to the question of prima facie jurisdiction, the Court observes that it may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, South Africa seeks to found the jurisdiction of the Court on Article 36, Paragraph 1 of the Statute of the Court and on Article 9 of the Genocide Convention. The Court must therefore first determine whether those provisions prima facie confer upon it jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. Article 9 of the Genocide Convention provides, I quote, "Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute." End of quote. South Africa and Israel are both parties to the Genocide Convention, and neither of them has entered a reservation to Article 9 or any other provision of the Convention. The Court then recalls that Article 9 of the Genocide Convention makes its jurisdiction conditional on the existence of a dispute relating to the interpretation, application, or fulfillment of the Convention. A dispute is a disagreement on a point of law or fact, a conflict of legal views or of interest between parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. To determine whether a dispute exists in the present case, the Court cannot limit itself to noting that one of the parties maintains the Convention applies while the other denies it. Since South Africa has invoked as a basis for the Court's jurisdiction the compromissory clause of the Genocide Convention, the Court must also ascertain at the present stage of the proceedings whether it appears that the acts and omissions complained of by the applicant are capable of falling within the scope of that convention, ratio materiae. The Court recalls that for purposes of deciding whether a dispute existed between the parties at the time of the filing of the application, it takes into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings. In so doing, it pays special attention to the author of the statement or document, its intended or actual addressee, and its content. The existence of a dispute is a matter for objective determination by the Court. It is a matter of substance, not a question of form or procedure. The Court notes that South Africa issued public statements in various multilateral and bilateral settings in which it expressed its view that, in light of the nature, scope, and extent of Israel's military operations in Gaza, Israel's actions amounted to violations of its obligations under the Genocide Convention. For instance, at the resumed 10th Emergency Special Session of the United Nations General Assembly on 12 December 2023, at which Israel was represented. The South African representative to the United Nations stated that, I quote, "The events of the past 6 weeks in Gaza have illustrated that Israel is acting contrary to its obligations in terms of the Genocide Convention." End of quote. South Africa recalled this statement in its note verbal of 21 December 2023 to the Embassy of Israel in Pretoria. The court notes that Israel dismissed any accusation of genocide in the context of the conflict in Gaza in a document published by the Israeli Ministry of Foreign Affairs on 6 December 2023, which was subsequently updated and reproduced on the website of the Israel Defense Forces on 15 December 2023 under the title, "The War Against Hamas, Answering Your Most Pressing Questions," stating that, I quote, "The accusation of genocide against Israel is not only wholly unfounded as a matter of fact and law, it is morally repugnant." End of quote. In the document, Israel also stated that, I quote, "The accusation of genocide is not just legally and factually incoherent, it is obscene, and that there was no valid basis in fact or law for the outrageous charge of genocide." End of quote. In light of the foregoing, the court considers that the parties appear to hold clearly opposite views as to whether certain acts or omissions allegedly committed by Israel in Gaza amount to violations by the latter of its obligations under the Genocide Convention. The court finds that the aforementioned elements are sufficient at this stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention. As to whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention, the court recalls that South Africa considers Israel to be responsible for committing genocide in Gaza and for failing to prevent and punish genocidal acts. South Africa contends that Israel has also violated other obligations under the Genocide Convention, including those concerning conspiracy to commit genocide, direct and public incitement to genocide, attempted genocide, and complicity in genocide. At the present stage of the proceedings, the court is not required to ascertain whether any violations of Israel's obligations under the Genocide Convention have occurred. Such a finding could only be made by the court at the stage of the examination of the merits of the present case. At the stage of making an order on the request for an indication of provisional measures, the court's task is to establish whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention. In the court's view, at least some of the acts and omissions alleged by South Africa to have been committed by Israel in Gaza appear to be capable of falling within the provisions of the Convention. In light of the following, the court concludes that, prima facie, it has jurisdiction pursuant to Article 9 of the Convention to entertain the case. Given this conclusion, the court considers that it cannot accede to Israel's request that the case be removed from the general list. The court turns next to the question of standing of South Africa. The court notes that the respondent did not challenge the standing of the applicant in the present proceedings. In the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia v. Myanmar, where Article 9 of the Genocide Convention was also invoked, the court observed that all states parties to the Convention have a common interest to ensure the prevention, suppression, and punishment of genocide by committing themselves to fulfilling the obligations contained in the Convention. Such common interest implies that the obligations in question are owed by any state party to all the other state parties to the relevant convention. They are obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. The common interest in compliance with the relevant obligations under the Genocide Convention entails that any state party, without distinction, is entitled to invoke the responsibility of another state party for an alleged breach of its obligations erga omnes partes. Accordingly, the Court found that any state party to the Genocide Convention may invoke the responsibility of another state party, including through the institution of proceedings before the Court, with a view to determining the alleged failure to comply with its obligations erga omnes partes under the Convention and to bringing a failure to the end. The Court concludes prima facie that South Africa has standing to submit to it the dispute with Israel concerning alleged violations of obligations under the Genocide Convention. To the question of the rights whose protection is sought and the link between such rights and the measures requested. It recalls that its power to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At this stage of the proceedings, however, the Court is not called upon to determine definitively whether the rights which South Africa wishes to seek protected exist. It need only decide whether the rights claimed by South Africa and for which it seeks protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The Court recalls that in accordance with Article 1 of the Convention, all states parties thereto have undertaken to prevent and to punish the crime of genocide. Article 2 provides that, I quote, "Genocide means any of the following acts committed with an intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. A. Killing members of the group. B. Causing serious bodily or mental harm to members of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the group. E. Forcibly transferring children of the group to another group." End of quote. Pursuant to Article 3 of the Genocide Convention, the following acts are also prohibited by the Convention: conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. The provisions of the Convention are intended to protect the members